holo ki hano o ka moku aina o Hawaii. E naui mai, e malio mai, I lohi ia kaleo. Hear ye, hear ye, hear ye, all persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalo. Please be seated.
Velina, makamoku puni o Oahu I ka moku o kona eia no kako ma aliolani hale. Greetings. On the island of Oahu in the district of Kona, we are gathered here at Aliolani hale. Please call the case.
Case number SCWC-24-0000619. In the interest of TJ, IT, AT1, AT2, and KT2, and in the interest of LT. Arguing for petitioner father, Lee Woodruff. Arguing for respondent, Department of Human Services, Deputy Solicitor General Lauren Chun. Arguing for guardian ad litem, Jamie DeMillo. Also appearing is Makia Minerby. Argument on the merits.
Aloha, kakahiaka, and good morning. Today's proceeding is being broadcast live on the Judiciary's YouTube channel, as well as on Olelo. And I'd like to welcome our substitute justice in this case, Judge Fa'aunga To'oto'o. Counsel, are you ready to proceed? All right. The court has allowed 30 minutes for each side. And to confirm, Ms. Woodruff, I understand you will argue for 25 minutes, then reserve any remaining time for rebuttal. And Ms. Chun, you have 20 minutes with a 5-minute warning, and Ms. DeMello, you have 10 minutes with a 3-minute warning. And I will remind counsel, please do not state any names in this case, just refer to parties by their status or by initial. Thank you. Ms. Woodruff, please proceed.
Good morning, Your Honors. I did not do it. I did not commit the act of which I am accused. The constitutions of this state and this country protect every person's right to freely choose the words they speak and to live free from compulsion to make statements that may incriminate them. Father asks this court to protect his rights to free speech and against self-incrimination. And the court can do so by making a broad ruling based on one right or the other right, or both, that will provide needed guidance in this area. Or the court can decide this appeal narrowly on the free speech grounds based on the unique facts of Father's case. Briefly, I will first discuss the narrow fact-specific option based on free speech. Certainly, the government has good intentions here. It aims to protect children from abuse. But that is not the issue on which the free speech analysis turns in this case. Regardless of whether strict scrutiny or intermediate scrutiny applies, the issue here is the second prong of the constitutional analysis. And the key is one unique fact: the no deception result on Father's polygraph examination. The government's own expert witness, Dr. Nahara, testified that he has treated participants for 22 years in CFS's Ohana sex abuse treatment program. When a participant denies alleged abuse, the treatment method is to encourage the person to take a polygraph exam. After the exam, Dr. Nahara or his colleagues share the result with the participant, showing deception, indicating that the person is lying when he denies the alleged abusive conduct. That is the treatment method, and Dr. Nahara testified that admitting the abuse is the final step to obtain clinical discharge from the treatment program. The problem here is that father's polygraph exam yielded a finding of no deception, meaning the technology found that father was telling the truth when he denied the alleged abuse.
Counsel, can I ask you on that point that you're raising with this doctor? He seemed to explain that it's a two-step process. Therapeutic steps, I believe, is what he called it, or therapeutic tasks. He said the first step was just showing up for the treatment, the appointment. And the second step, he said, was the admission. How does the polygraph play into his treatment steps? It just wasn't that clear to me as to how that all interacted.
Right. So this presented a unique circumstance for Dr. Nahara. He testified this was the first time in all of his 22 years in the position that they received a no deception result on the polygraph.
And he didn't seem to know what to do with that.
Correct. It left him wondering what to do. And
in fact, he wasn't sure if he should proceed with treatment. That's the way I read the transcript. Is that
correct?
accurate?
The situation presented effectively a dead end in the treatment protocol that I just described. So Dr. Nahara met with DHS's social worker and case manager, Renee San Nicolas, and Dr. Nahara said to her, essentially, father has shown up. He has participated in therapy. But due to this no deception result, we're at the end of the program for him, essentially.
Okay, so if you don't have a deceptive polygraph result, is it the treatment protocol that an admission is no longer required?
Well, that's exactly what Dr. Nahara asked Ms. San Nicolas. He said, in this unique case...
Why is he asking her? It's his treatment plan.
Well, because he's acting as a contractor for the government, for DHS.
But he's providing the treatment and formulating the treatment plan. Is that
correct,
correct understanding?
Yeah, and I think he said to her, essentially, I'm at the end of my treatment with him because there's just this not this other step available, right, to show him a deceptive result and talk about it in treatment and therapy.
Okay, so in reading the record, the admission wasn't a critical piece of the treatment given the circumstances of this case. Is that an accurate read?
That's how I read it, Your Honor. And so that's basically what Dr. Nahara said to Ms. San Nicolas and said, in this unique case, can we issue a clinical discharge? May I do that? And DHS, through Ms. San Nicolas, said, no, treatment must continue. And again, that left Dr. Nahara wondering, what does that mean here? And it means Dr. Nahara cannot clinically discharge father unless he speaks the words, okay, I admit I did it. And for shorthand, I've called that the abuse admission mandate. So this appeal can be decided narrowly on free speech grounds based on the unique facts we just discussed. The abuse admission mandate unlawfully infringes father's right to free speech because the government's method, the treatment method of Dr. Nahara that we discussed, is to get a person to admit abuse if he denies it.
Could you hold on for a second? Mr. Shibata, could you ask them to stop the blower? Thank you.
May I proceed?
Yes.
Okay, thank you. Right, so the method to get a person to admit and complete the program is to show a deception result from the polygraph. But due to father's no deception result on his polygraph, that method was not available to Dr. Nahara and his program. And it certainly could not be narrowly tailored or even substantially related to achieving the government's interest.
Well, part of the issue in this case is that the family court's order specifically incorporated the service plan, which specifically required acknowledgement of the abuse, to paraphrase the service plan. Where does the court's order place in terms of the analysis, in terms of your view that it can be decided narrowly?
Can you repeat the last part?
In terms of your view that this case can be decided narrowly, the fact that we have a court order specifically incorporating a service plan that in turn specifically requires acknowledgement of abuse,
Right. So my understanding is that actually the family court has recently, I think in October, adopted a new service plan with a new therapist. So I am not sure what that therapist will do. The record is silent as to whether she will require father to admit the abuse. However, I must add that Ms. San Nicolas testified in the trial that every government contractor who provides this therapy service requires an abuse admission.
The modified order, which was entered while this appeal was pending, I don't know if that's necessarily an issue or not, but the modified order still continues to contain the language similar to the prior orders requiring acknowledgement in the service plan, right? Where it adopts the service plan, which has that language.
Right.
So
I guess the decision would be from this court that to the extent the court adopted the plan's requirement implicitly through the contracting, that a father, a parent must admit abuse, that's not constitutional on these facts as applied.
Yeah, I'm just trying to get at the question of you're stating that this case can be decided narrowly, and I appreciate what you're pointing out. I'm just trying to figure out in your analysis of a narrow ruling where that court order, how that court order should be treated in light of the language in it adopting the service plan.
Yeah. I'm not quite sure how to answer your question, honestly, Justice, but...
Well, are you just looking for that term to be stricken, the acknowledgement, the admission that's being required? Because a modified plan still has, as Justice Ganoza pointed out, that hasn't changed.
I think...
The admission requirement, are you asking,
right,
that's the unconstitutional part you're asking to be stricken? Is that where you're going?
It is. The problem is the word acknowledgement in the order and in the service plan is not what happens in the therapy, right? The therapy is an admission requirement. So perhaps the order has to be clarified, and the service plan too, that acknowledgement cannot be...
Wait, do you differentiate between acknowledge and admission? You think those are two different things? Because that'd be an important distinction, because the court's not ordering, the service plan isn't ordering a, quote, admission. It's just an acknowledgement. That may be two different things.
Yeah.
Speak to that?
I think here acknowledgement of the abuse is the same as an admission, but there are some cases where the language has been a little softer, like feeling remorse, that kind of thing.
Well, the doctor said admit. That's the word he used.
Oh, yeah, for sure.
Would the same concerns apply here is the concern that the order requires acknowledgement tantamount to admission, which is potentially compelled speech?
Yeah.
If that was gone and the order was you must complete substance abuse abuse treatment, whatever that type of abuse treatment might be, would that, but the provider requires admission, would we still have the First Amendment issue if the court order did not say you have to acknowledge and or admit?
Well, DHS is a government actor, and to the extent it is contracting only with providers who mandate an abuse admission to finish the program, the government...
So, I used the word substance earlier. So if the court orders substance abuse treatment through Salvation Army, which requires like acknowledgement of a higher power, does that raise the same concern? Or is it perhaps the court can order treatment by someone that is not faith-based, an entity that is not faith-based?
It raises some concerns for me, and the distinction here is there is no possibility under this record for a parent to get any treatment service for sex abuse treatment from any contractor that the government will accept without admitting abuse. That's what this says. I don't know the circumstances of the substance abuse treatment, if there are other pathways to completion, but I think that's the distinction.
Is the record sufficiently developed to determine why there is this requirement for an acknowledgement?
Why there
Why
is
therapists would require such an acknowledgement? Is that necessary for us to have more information about? I mean, this issue about First Amendment was raised for the first time on appeal, right?
correct. Although trial counsel did say in his closing statements that he thought it was unfair and unjust. So this brings me, I want to move from the narrow decision into the free speech ruling that the court could make more broadly.
Well, I hope you address the question as well.
Yeah, so I think this has to do with conduct. The government says that it is trying to change conduct, not speech, right? So, but what conduct? The government argues it wants father to change his conduct by accepting responsibility and becoming reformed. But the government cannot know if a person subjectively accepts responsibility or changes in his mind or his heart or his soul. And the ICA recognized this in State v. Reyes, 93 Hawaii 321, when it quoted a law review article entitled The New Inquisition, in which the author observed that the problem with state treatment programs that mandate confessions is that they're not based on science. There's no record of why there's therapeutic value in such confessions. Instead, the programs tend to, quote, fetishize confession, unquote, like medieval inquisitors extracting an admission of witchcraft to save souls. Here, and I suspect another case, DHS introduced zero evidence about any therapeutic value of making father confess, making him change the words that come out of his mouth. The content of his speech, from I did not do it to the opposite, I admit I did it. For example, no expert testified based on scientific research that forcing a person to speak the words.
So what you're saying is that without an admission, the treatment may be as effective or maybe even more effective, but the admission isn't needed. Is that where you're going with this?
I'm saying there's no evidence in the record that it's needed, that it will help to achieve the government's goal. Okay.
Well, and I think Reyes, that's exactly what it was talking about. Now, before you move into the next point you were going to do, and I think this might slide you in there, is I was wondering about the statutes. When you're looking at, say, when you get to the parental termination hearing, the 587A33 part, but you also look at 587A7 subsection 8, and both of those statutes seem to require an acknowledgement of, responsibility. And I take that, as you do, as an admission of guilt. What's your position on those particular statutes? Because it seems like the service plan and the modified service plan and all this is kind of geared to those two statutes and what they actually say.
Yeah.
What's your position on those statutes?
Well, although it's not necessary to decide this issue today, I do think to the extent that they have been interpreted by the court, family court, and by DHS to require an admission that they do violate the right to free speech.
But isn't it more the right to self-incrimination than free speech? And I look at some line of cases throughout the nation. It's more tethered towards that particular right. And that particular right strikes me that there's the violation. It's almost like an autonomy, as you're being compelled to admit to something. And that violation happens right then when you do admit to it. And if that's being required in the whole process or in the treatment process, what's your position there? I think I know what it is, but why don't you flesh it out for us?
I do agree that there is a violation of the right against self-incrimination so long as there is not an immunity order in place. Now, again, here there's been some occurrences since we filed this appeal and the court accepted review.
Well, let me ask you about that. And you call it an immunity for it. I'm not so sure that's immunity. That is an evidentiary statute, and that's an evidentiary statute that I see as the family court tying the hands of other actors in the system, whether it's the criminal justice system or the civil justice system. And that particular inadmissibility aspect of 587A20 doesn't really protect, because if it's just the evidence that's produced during those sessions and that can't be used, that doesn't mean that law enforcement can't use information from there to then, lead to admissible evidence. What do you think?
I do agree. There is definitely a very real risk of incriminating oneself.
And then let me ask you about the practical aspect of that. And I don't think it's an immunity statute, but, that statute. Let's say the person there in the session, and I'm just talking generally, but it kind of will tie a little bit in the facts of your particular case. Let's say that person not only admits to or accepts responsibility to one particular victim, but then says, hey, look, the other 4 children at issue here, I did stuff to them too. Is that statute really going to shield the confession to 4 separate people? Do we think that's truly there to protect this defendant? And then why should we protect that defendant if in the therapy session that person says, I did 4 more, the other 4 children?
Yeah, well, the answer is probably it's not going to protect him. And there is going to be reporting of what happened to law enforcement. But
and that sort of led me to my next part. How does this 587A20 relate to the mandatory reporting requirements?
the answer from me is it's unclear.
So
It's
587A20 is just sort of a meaningless statute, maybe. I just make a comment, so please proceed.
Okay, well, let me return to,
Wait, can I just pick up on that, on just mandatory reporting? Because the service plan at the end has language about mandatory reporting. That's the obligation of those involved to report such information.
that's
So
correct.
it is clear. Why is it unclear?
Why is it unclear what would
As far
happen?
as reporting, the obligation. Because the service plan references specifically that there's a reporting obligation. And that if the police call, you have to provide the information.
Right, I think I was responding that it's unclear as to what effect an admission in therapy will have down the line on a person, an investigation and later prosecution.
And I understand, I guess, trying to figure out what's the scope of what's been called immunity? What's the protection that's actually been given by this 587 Alpha-20?
Right, so that's what's unclear to me. Okay. So let me turn to the third alternative I see, where the court can rule broadly to provide guidance, not just on the speech issue, but to protect a parent's right against self-incrimination, as we were discussing. The question is, does the Family Reunification Service Plan, like Father's Plan here, unlawfully coerce a parent to choose, right, between 2 constitutional interests or rights? Here, we have choice 1 for father. He can waive his right against self-incrimination by admitting the alleged abuse to complete the plan and preserve his chance to reunify with his children. And his second choice is to forfeit his substantive liberty interest in his parental rights if he exercises his right against self-incrimination and continues to maintain his innocence. And those are father's choices that he faces here.
You're not arguing that the statutes that do require acknowledgement or admission are facially unconstitutional, correct? It's just an as applied when the statements might lead to criminally incriminatory statements that it raises the issue, correct? Because they might be asked to acknowledge that they weren't the best parent by not letting them play with their friends or something, I mean, that's not, doesn't have criminal consequences.
Sure, and there are cases from other jurisdictions, some of which we cited, where acknowledgement can be something less than I caused this injury. It can be I acknowledge that this child was in my care and this accidental injury happened. So no, I'm not making a facial challenge today to the statute. But I do want to talk about, I think there's a 2-part proposition from those cases from other jurisdictions that the government and we agree with. And part one is that it is lawful to require a parent to complete therapy as part of a family service plan. But part two is that the service plan violates a parent's right against self-incrimination if the therapy program, the only ones available, require a parent to admit committing the alleged abuse. The government argues that the service plan here comports with the proposition I just described because theoretically, completion of a service plan is just one factor that the family court can consider, but the government cites no case where there was reunification after a parent did not obtain a clinical discharge. And the judge's warning in this case was pretty clear that if you don't complete services, and the only service not completed was this one, you're going to lose your kids. The government also suggests at footnote 14 in its supplemental brief that father may be able to complete a program by participating in all the other components of the treatment. But again, that argument is contrary to the record because both Ms. San Nicolas for DHS and Dr. Nahara testified that treatment is at an impasse. The only way for him to complete is to admit.
Are you arguing that without this admission requirement, without completion, there was insufficient evidence to support the family court's other findings to move toward adoption?
Yes, because a service plan, as the government argues in its brief, is the roadmap for a parent, right? The tasks, like, for example, obtaining stable housing and employment, which father has done, and the services that a parent must complete to demonstrate that they're now able to provide a safe family home for the child. In this case, all of it happened. This is the one thing remaining. It's the barrier to father's reunification.
Wait, but didn't it seem that there were other of the 587A7 factors that the court was considering aside from successful completion of a treatment program? I think there were, but perhaps is this the type of factor, though, that could overwhelm all the other factors and it alone result in, denial of substantial rights?
Yeah, I do think so. Ms. San Nicolas was asked in her testimony, has father done everything else? And she said, yes. She said, this is it. This is the barrier, right, to completing everything that DHS wants father to do. And to the extent that the court considered things outside of the roadmap that father achieved essentially by all of his work, I think those were less important considerations based on the testimony.
So the cases across the country, though, understandably, you're talking about father's rights, father's constitutional rights, obviously important. But cases across the country talk about the balance because obviously, as you briefly mentioned at the beginning of your remarks, we're talking about the welfare of children who two of whom claim to have been sexually abused. Mm-hmm. Where does that balance come in then?
Mm-hmm. Well, I think this goes back to the question of the efficacy, right, of the treatment model here. There's no evidence in this record that this abuse admission mandate furthers the government interest in protecting the children.
Well, I think that's my question in terms of whether this record is sufficiently developed to address the issue that is now being raised for the first time on appeal, and whether we have the information on that efficacy question that we need to have to make this important decision.
Well, the government, did not introduce any evidence at trial. And
because this issue wasn't challenged. Because this issue wasn't challenged at trial.
Right. And I think that's just the practice. That's the practice. There's an assumption that this kind of admission somehow makes a person accept responsibility inside of them. And there's not scientific evidence.
But you're asking us to make the opposite assumption without anything in the record, right?
No, I think I'm asking Your Honors to look at the evidence presented and apply the constitutional test, right? And so far as the speech test, that is whether this method, requiring someone to admit abuse, is sufficiently tailored to make that person reform so that he will not abuse a child in the future.
Last question before I know your time is come. Are you asking us to come to a conclusion or decision that would essentially mandate that such an admission cannot be required in any therapeutic setting for a parent alleged to have abused their child?
Mm-hmm. I would say absent scientific and expert testimony to be admitted that is going to be effective, yes. Mm-hmm. So I see my time is short. But in sum, on the self-incrimination, yes, therapy is something that the court can mandate. But a service plan violates a parent's right against self-incrimination if it requires father to admit abuse. So in conclusion, father asks this court to hold that the government service plan is unconstitutional as applied to him because it conditions father's parental rights, his opportunity to reunify with his children, on father changing the content of his speech, on speaking words he does not wish to say, words that may incriminate him, the words the government wants him to say, okay, I admit I did it. And without saying those words, he cannot obtain a clinical discharge from CFS's sex abuse treatment program. And that is the barrier remaining between father and completing the tasks and services that the government assigned to him to reunify with his children in the service plan. So for these reasons, the service plan violates father's right to free speech and his right against self-incrimination. Thank you.
Thank you. Ms. Chun, your argument.
Good morning, Chief Justice McKenna, Associate Justices of the Hawaii Supreme Court. I'm Lauren Chun, Deputy Solicitor General, appearing on behalf of the Department of Human Services. Your Honors, when children are placed into protective custody because their parents have abused them, the courts have an obligation to ensure that those children are not returned to their parents unless the court is satisfied that the abuse will not continue. Failing to do so puts children's health, safety, and at times their very lives at risk. And in this context, the court should be allowed to look at a parent's words or actions as evidence of whether they continue to pose a risk to their children's safety. Doing so is not punishment for those words or actions, but instead it's necessary to ensure that the child is not returned to a harmful situation. I'd like to address some of the facts that were brought up by my opposing counsel that we would like to clarify and might disagree with. The record here does not show that the DHS is controlling Dr. Najera's therapeutic modality. What Dr. Najera what his opinion was, he was not brought in to determine whether sex abuse treatment was necessary. In relying on whether abuse treatment was necessary, the court relied on a multitude of other factors, including father's sex abuse history, the statements of his previous treatment provider, his psychosexual examination, which showed he was at an increased risk of reoffending, and most importantly, the report of a multidisciplinary team, which took all those factors into consideration and also took into consideration his polygraph exam and said, we continue to believe he is in need of sex abuse treatment. And we, as professionals, mental health and social work professionals, think that he needs to address issues of accountability and victim blaming and addressing the mindset that leads him to this abuse. What Dr. Najera was explaining was what I guess what he was confused about is whether DHS still wanted him to proceed with the treatment. And if I could back up a little bit more with respect to the polygraph test The questions were not provided by Dr. Najera. The evidence, the record doesn't show this is the type of polygraph test that he would use in formulating his program. It just says he would, use a polygraph test, but the polygraph test questions in this case were provided by the father. And what the trial court described and explained pretty clearly in its findings was that these results did not indicate that he did not abuse his children. The polygraph test results, the questions that were asked were only, did you touch your children for sexual gratification purposes? And the trial court, again, based on the testimony of experts, said, well, that doesn't negate the possibility he touched them for any other purpose, including to hurt them, embarrass them, exercise control over them. And we have statements by the children themselves saying they were abused. So that's all part of the record that led the trial court to determine that sex abuse treatment was necessary. And Dr. Najera, I don't believe his testimony was that DHS was forbidding him to clinically discharge this man until he acknowledged abuse. He said part of his program, what he was in charge of, was certain steps. And one of those therapeutic steps, according to him, the expert, one of those steps was to acknowledge responsibility for the abuse. His question to DHS and to the family court was, do you want me to continue? And again, based on the finding that father did sexually abuse his children, and based on the opinions of other experts that treatment was necessary, the response was, yes, please continue with your treatment. And I also want to address this assertion that acknowledgement in a therapeutic context, in the therapeutic context, is the same as an admission of guilt. The record, I don't think, bears that out. We don't know that something short of an admission that, yes, I sexually abused my children is not going to be sufficient to acknowledge responsibility in the therapeutic context. In other situations, one could say, I acknowledge I did something that placed my children in harm's way. I acknowledge I did something that was traumatizing to my child without having to admit guilt for a specific criminal act. So
Yeah, but I mean,
yes.
isn't this situation more binary than that general situation?
I don't think so, and I don't think the record bears that out. Even though Dr. Najera might have said admission in his testimony, again, this issue about this specific requirement, whether it's specifically necessary in therapy, was not developed in the record. It wasn't challenged. And, father was represented by counsel. He had every opportunity to challenge that requirement if he thought it was not necessary for his case. So we would agree that our opinion is that the record does sufficiently show why this was sufficient, why this service plan was narrowly tailored to this father, again, given his history, given the opinions of other experts that testified in this case and given their reports. But if this court finds, well, we don't know exactly, the distinction between acknowledgement or admission, or we don't know exactly why that might be a necessary part of therapy, then it can remand for further fact findings on that issue. But again, our position is that the facts in the record are sufficient to show there is narrow tailoring here.
Counsel, can I ask you about the what's been referred to as the immunity statute, the 587 Alpha 20? It seems that the court invoked it on the modified
Yes.
order, the modified plan. But it's not clear to me what it really means and how it's applied, because the rule as I read it, it's got to be invoked in the best interest of the child.
Yes.
And that's not knowing what evidence or what's being addressed. And the court seems to already be making a judgment call on that. And it also seems to apply where you can't use the admission for later use, but you can take that admission and see where it might lead you to develop other evidence, to build a case against father. Is that the way you see how that provision applies, or you see it differently? Or maybe you're not sure.
I guess that the short answer is I'm not sure, and I don't think this statute has really been tested yet. I will say in this case, it's unclear, what I guess it's unclear whether there would even be additional admissions or acknowledgments in therapy that would add to what has already been reported to HPD and what the family court already found.
But you never know, and it's the unknown that I'm wondering about, because that invocation of that statute has to be in the best interest of the child.
Yes.
So if someone is admitting to having done some very inappropriate things to a child, I don't know why keeping that out would ever be in the best interest of a child. When would it be? And then they throw in, oh, by the way, I also touched some other kids inappropriately, because many times we know that they're serial.
Right. No, it's understood. So I think that's why it leaves it to the discretion of the family court to determine best interest. It could be in the best interest of the child. We could think of a situation where maybe the court is convinced that this parent has a really high likelihood of being rehabilitated, and the only thing that's keeping him back is that he doesn't want, that he's afraid of acknowledging that in therapy. Maybe the court thinks, well, in the child's best interest, if this is the only thing that's keeping them apart from a safe parent, then this statute should be invoked. And that clearly was in this case.
Yeah, it just doesn't seem very solid to me that you know exactly what you're being given immunity for. But anyway, thank you. Appreciate it.
Understood.
Are you characterizing this as an immunity statute? It doesn't even use the word immunity. It's an inadmissibility statute, and it doesn't even say fruit of the poisonous tree would not also be excluded. So in other words, as has been alluded to here, the state could, based on this, develop other evidence of the same facts.
I would suppose that's possible, but I think it's speculative in this case to say it doesn't protect father's Fifth Amendment rights. We know that the service plan was modified to include a treatment provider that apparently father is agreeable to. 587-820 was invoked. So we don't know at this point in the record, it doesn't show that father is even going to either refuse to participate in therapy with this treatment provider.
But he may not even want to take a chance because it's so unknown. I mean, that seems to be, what do we do with that? I mean, he's not even sure what's going to be kept out. It's basically a evidentiary exclusionary rule the way I read it. It's not immunity.
Right, so.
I know it's been referred to as immunity, but I really don't see that.
Right, so I would agree that it doesn't preclude totally the use of statements for investigatory purposes.
Right, so it could be used against him.
It could be, but again, at this point in the case, it's speculative as to whether he's even going to continue to deny to participate in treatment with the new provider, whether he's going to suffer any consequences. It could be that he completes treatment with this new provider, which would moot out the entire necessity of deciding the constitutional issues here. Or it could be that he continues to refuse to undergo sexual abuse treatment, and the court either terminates parental rights based on completely separate reasons, or says, all right, you've refused to complete sexual abuse treatment, but it's only because of this one component. Maybe he's satisfied every other condition of the plan. Maybe the experts say, well, no, we still think he's probably not going to pose a threat to his children anymore. Maybe the children want to be reunited with him. There's a world in which this does not prevent him from being reunited with his children. And I think that's another important distinction to make. Some of the orders that were found unconstitutional in the Fifth Amendment context are orders which specifically say, if you don't admit to guilt, we are going to terminate your parental rights. And that's not what the service plan is doing here. It's saying, these are facts that we are going to look to determine whether you can safely provide a home for your child. And that's really the goal of the Child Protective Act. It's reunification. It's not a punitive statute. It's remedial. The court wants to give notice to parents to give them a pathway to reunify.
When you're talking about route to reunification, it seems like that route to reunification has a non-negotiable you got to complete this program or you're not going to be reunited. And you know what? To complete the program, you have to acknowledge, accept responsibility, admit guilt, whatever term we're going to use. It seems like there's that precondition. And I'm just wondering how that does not violate the right against self-incrimination.
So I would disagree that it's.
And let me
yes.
just follow up one more, because you're almost tethering this significant benefit to that compelled speech. The significant benefit being, of course, restoration or maintenance of the parent-child relationship, which itself is a fundamental liberty interest.
Right. So I would disagree with the contention that it's a precondition. As I said, it's possible that father could refuse to complete treatment and not be foreclosed from reuniting with his children. What the court has to do is look at the totality of the evidence before it. Sex abuse treatment is just one component of that.
Along those lines,
yes.
the family court indicated one of the conclusions was that the father is not engaged in services. Therefore, it's not reasonably foreseeable that father will become willing and able to provide the children with a safe family home, even with the assistance of a service plan. What other services was the court referring to other than this?
Well, I know the service plan also recommended domestic violence treatment. I'm not sure. I can't say whether he was engaged in that or not. And I believe there were a list of other services in the service plan. But if I can refer to one of this court's precedents in the Inri Doe case in 2001, I think that's a really good demonstration of why courts have to be able to look at what parents say or choose not to say when they determine whether they can be a safe parent for that child. In that case, that involved a mother who had a history of having relationships with abusive men. And she refused to acknowledge that her current partner was abusive, even though it was established that he had abused her daughter. The social worker in that case told the court, based on her denial that her partner is abusive, I can't say that she is going to be able to adequately protect her child. And this court, in that case, that is one of the factors that justified terminating her parental rights. So again, whatever this court's outcome is, it has to allow family courts to look to the
opposing counsel has conceded that she's not making a facial challenge to the statute, and therefore situations like that do not rise to someone being forced to make incriminatory statements would not be unconstitutional.
Okay, so that's good. But and then for this case, again, I've already talked about why this particular treatment plan is narrowly tailored to this father. And then broadly, even though that is counsel's argument, I mean, the necessary implications of her First and Fifth Amendment arguments are that courts have to ignore treatment providers if, again, if there is a record that says treatment providers agree that an acknowledgement of responsibility is necessary for a parent to be rehabilitated, courts have to be able to rely on their professional opinions when they decide whether children can be safely reunified with their parents.
One of the things that Ms. Woodruff, one of the things Ms. Woodruff was arguing was that essentially DHS controls who the parents will obtain therapy from, and that essentially, I think the argument, as I heard it at least, was DHS is only picking therapists who require such an admission. Can you address that, please?
Sure. Well, I think that the alternative of that argument is that courts have to be able, or that courts have to be forced to choose treatment providers that only, or excuse me, let me try to rephrase this. I think what the implication of that argument is that courts then have to be forced to select treatment providers who do not require some kind of acknowledgement as part of their treatment program. And that would jeopardize the safety of children if it is the case that the reason why the majority of treatment providers require this acknowledgement is because it's the consensus of the professional community that is a necessary step.
Where is that in the record? How is it established that this is evidence-based.
Sure. So I will concede that this record is not well developed as to that point. The Guardian ad litem's brief, I will point out, though, does contain a lot of evidence of the professional consensus of providers, as well as the acknowledgement by the Supreme Court that rehabilitation requires someone to acknowledge responsibility.
But in this specific context, that sex abuse counseling treatment is not effective unless the alleged perpetrator admits to it. Where is the evidence on that?
So there is scant evidence on that in this record, again, because this issue wasn't brought up. But Dr. Najera does say that this is a necessary therapeutic step of his program. And he was the person that father qualified to be an expert in this case. So based on his testimony, that indicates that there is a treatment provider, a professional expert treatment provider who says this is a necessary step to complete therapy and to be rehabilitated.
Excuse me. How was father's new treatment provider selected?
My understanding, and I'm sorry, I don't know.
That's in the
exactly.
modified.
In the modified plan, I believe he is receiving treatment from her. So I believe it's because that's the provider that he would have preferred.
That was the part of the reason why the court went back and modified the order?
I believe so. And I'm sorry, and I can be corrected if I'm incorrect, but that's my understanding.
So, Ms. Wood have brought up the Reyes case, and I think you're probably familiar with that, which I guess cuts against the grain of some of what you just talked about, effective treatment. But let me ask you this. If say a treatment provider does require the admission, and the person, goes through the program and meets all the requirements of the program except the non-compliance with the admission, is there anything wrong with, fashioning some sort of guidance that if that happens, the court cannot base its decision solely on the admission? In other words, the fact of the treatment comes in, and the treatment provider might say, well, they weren't clinically discharged, which I think is probably a hazy word. It matters to them, but maybe it doesn't matter so much to the system. As long as the court doesn't solely base it on that admission, would that be fine?
I think that would be fine, and I think that is what the Fifth Amendment cases. I think that's what the majority of them hold, is that a court can't say, we are terminating your parental rights based solely on your failure to incriminate yourself. But I think what a court has to be allowed to do is say, well, you failed to complete treatment, and based on the remaining record, we can't say that you've proven that you can be successfully reunited.
Well, it might not be they failed to complete treatment. Say they actually did complete treatment, but just didn't get that little.
Understood. Yes. So I guess it would depend on the reasoning of the court. Is it going to be just we're terminating your parental rights because you failed to incriminate yourself, or is it going to be you failed to incriminate yourself, but based on the totality of circumstances, we think that the balance of evidence shows you cannot be a safe parent? I think the latter has to still be allowed and must be allowed if courts have to fulfill their duty to protect children while still, not directly punishing parents for making incriminating statements or failing to make incriminating statements. I'm sorry.
I'm sorry, can I just ask this question? Are you taking a position that there's no way that the treatment goals can be met without the admission?
In this case, I think that is what the record shows, based on what Dr. Najera said about his treatment plan. But that might not be the case in every situation. And again, I think, like I said, there's a possibility that father doesn't complete this treatment, but maybe the balance of evidence still does show that he is a safe parent, that the service plan doesn't foreclose that possibility. So I know that I'm out of time for my portion, Your Honors. I just want to emphasize that courts cannot adequately protect children if they're forced to ignore the opinions of professional treatment providers who would say that a particular parent has not shown through their words or actions that they've been successfully rehabilitated. in this context, looking to the parent's words or actions and looking to the opinion of a professional treatment provider does not punish parents for their messages, for what they choose to say or not to say. What it is instead doing is fulfilling the court's essential duty to protect children from future harmful situations. And that's what we respectfully ask this court to do in this case, to uphold the family court's efforts to ensure that these children at issue, the ones we're talking about in this case, are not subjected to any further abuse than they have already endured. Thank you.
Thank you. Ms. DeMello?
Good morning, Chief Justice and Social Justices. My name is Jamie DeMello on behalf of the guardian ad litem. Thank you for allowing me to be here today. Two things are true in this case. No one should be compelled by the government to say anything that they choose not to say. And the family court must be able to determine whether or not a parent with a history of sexually abusing multiple children can provide a safe family home moving forward. The tension between these two principles lies at the heart of this case. On one hand, it can't be true that a parent's right against compelled speech is so strong that they can't be required to complete sex abuse treatment. Especially in a case like this, where father has been convicted of sexually abusing a minor in 2015, is a registered sex offender, and had completed sex offender treatment prior to abusing 2 of the 5 young children in his care. On the other hand, it can also not be true that a parent must confess to abuse or lose their children permanently. Stuck in between these two extremes is the best interest of children. It is almost always in children's best interest to have meaningful contact with their biological parents, even if those parents have harmed them in the past. But it's never in children's best interest to put them in a situation that can cause them harm. Children who have been sexually abused deserve the protection from their abuser, and no child should be sent to live with or depend on their parent when we know that there is a risk that their parent will harm them again. The family court needs to consider seriously that the risks in the family home are borne by the children. In reconciling these competing interests, the JAL says that we only need to look at Chapter 587A7. The goal of the Child Protective Act is to safely reunify victim children with their offender parents. In doing so, the family court must also consider all of the safe family home factors discussed in 587A7. This court has asked some very interesting questions this morning, and the JL would like the opportunity to address them in turn. From the JL standpoint, the family court should have the opportunity and is mandated by not only the statute, but this court to review all safe family home factors fully and completely. Not only is the court to consider whether or not a parent has completed services, whether or not they've acknowledged responsibility for the harm that was caused to the child, but the family court is required to look at the child themselves. In a majority of these situations, and in this case, the child themselves would be participating in some kind of therapy to help them to understand and reflect and hopefully get support for what's happened to them.
For the two important principles that you've laid out here,
Yes,
and I agree with that, does it make a difference whether the court's order requires the acknowledgement or admission as opposed to requiring a meaningful therapeutic treatment plan?
Yes, Justice. So when we look specifically at the family service plan, the goals of treatment is so that father can identify and understand the sexual victimization and the dynamics of sex abuse. There's no requirement within the words of the family service plan, nor at the end of trial that said, if you do not admit that you're going to lose your children. There have been cases in the Fifth Amendment discussion where that was the case, where the court did order a specific admission. And in those cases, those courts have said that that's unconstitutional. But it is constitutional to require a parent to participate in therapy. And if they fail to complete therapy because they refuse to admit or take responsibility, that's still something that the court can take into consideration.
Do you think there is enough in the court's findings and conclusions to uphold the move toward adoption without the issue of the alleged failure to admit to sexual abuse.
So, Justice, where we are in the case, from my understanding, is we haven't really got to the point where we're even talking about termination. We're still at the point where parents are completing services. So, if a court were to sit on the record today, there hasn't been enough analysis of all of the factors to make a determination about whether a parent can provide a safe family home, which is why it's difficult to say with certainty whether or not a parent's rights will be terminated based on the record before us.
Yeah, I have a question, or and maybe you can help me out here. Is okay. So let's say there's the father denies it. I didn't do this. I want a jury trial. I want all the protections there. This judge in family court just looked at some reports, took some testimony. I didn't have those full protections. I want this. I love my child. I wouldn't commit incest. I wouldn't do any of this. And then you contrast that person who then doesn't want to do the treatment or doesn't want to admit. You contrast that with the other individual who says, yes, I am a very sick person and I want treatment. And they admit that. In looking at the best interests of the child, it seems that perhaps you might rather take your chances with the person who says the court might have made a faulty ruling and I've been falsely accused, than to give or credit the confirmed pedophile. What do you think?
So, Justice, I think within the context of child welfare, we would have to bring it back to those safety home factors. A parent can admit that they sexually abuse their child and then do nothing with that admission, choose not to participate in services. And that in and of itself is going to have the same weight, because this court said that no one factor can be determinative of whether or not a parent's rights are terminated, will be given the same weight as all of the other factors. And so when we're looking at, in your example, Justice, what would be easier for the therapist in that situation to ascertain is the triggers and factors that led to the abuse, so that the therapist can help the parent understand those triggers and factors and give them tools so that they won't abuse it again. That's essentially the point of the treatment under the Family Service Plan, is to be able to help that parent understand why they did what they did, so that they can address it and move forward and hopefully reunify with their children. The goal of these cases is reunification at the end of the day. So how do we help these parents and these children get to the point where the safety risks are addressed and we can reunify them, hopefully happily, with their family?
And also, every case can be very, very different. You can have a situation where somebody is alleged to have continuously sexually abused a 5-year-old over the course of 5 years, starting at 5, going to 10. That's a very different situation than perhaps other situations, including this one.
Yes, Justice.
In terms of the allegations.
Yes, Justice. And that's why it's so important that the family court be able to fully assess all of the 14 factors under 587A. I should note that there was some discussion around the sufficiency of 587A20. I will just note that the Intermediate Court of Appeals in In Re K, in the interest of SA and In Re P children, had found that 587A protections were sufficient, particularly in those situations where father didn't want to testify, in P children, mother didn't want to do drug abuse services because of her concerns around criminal implications. And so we do have some guidance from the Intermediate Court of Appeals that that kind of protection is necessary. But if this court determines that it's not, you have the freedom to make some changes to that. Ultimately, what the guardian ad litem is asking this court to do is to allow the family court to continue to review all of the factors, review each case individually, treat each child individually, so that they can be able to reunify. As far as the Fifth Amendment, justices, this court had kind of alluded to, Justice Evans had alluded to a rule around making sure that, a parent's rights are considered, but still be able to participate in treatment. There are cases across the nation that talk about that. For example, the Nebraska Court of Appeals, and in the interest of Clifford M., stated that there's a very fine line and an important line between the distinction of terminating a parent's rights based on their specifically their refusal to waive their protections under the Fifth Amendment, and terminating parental rights based upon the parent's failure to comply with an order to obtain meaningful therapy or rehabilitation. And so it is this fine line that I think the court can consider looking at and saying that, you know, parents, and who am I to tell the Supreme Court what to do? Just something to think about, that the family court can consider and continue to require parents to participate in therapy, and that any admissions made in therapy cannot be the sole basis for terminating parental rights. We would ask this court to fully consider children's best interests when balancing parents' constitutional rights, and we hope that this court will make a decision to find that the family service plan is constitutional, and allow children to continue to be protected under the state constitution. Thank you.
May I ask you just very quickly, you know, you referred to that K-Children case.
Yes,
Do you
Justice.
consider that 587 Alpha 20 as providing immunity or something less as far as protecting the self-incrimination right?
So, Your Honor, I think that it does, it is more of a evidentiary than an immunity per se.
So less.
So less. But I do think that it does meet the spirit of the CPA, which is what's in the children's best interest. And that analysis needs to fully addressed. It was not addressed in this case below until it was ordered later on. Thank you.
Thank you.
Thank you. Rebuttal, Ms. Woodruff? We'll give you a few extra minutes.
Okay, I want to address the comments that were made by both of my colleagues about the fact that the Child Protective Act and the work of DHS and the courts is not meant to be punitive to parents, okay? Whether or not it's intended to be punitive is not part of the self-incrimination analysis. As we talked about earlier, there's two prongs. The first is risk of incrimination. And as we discussed, even with the current order in place, there is still a risk of investigatory implications and also prosecution later. And two, the second part is, does the penalty amount to compulsion? And on this point, I would recommend, I found very helpful the McCune v. Lyle decision from the Supreme Court, particularly the widely cited concurrence of Justice O'Connor, who explained that penalties severe enough to offend the Fifth Amendment privilege include termination of employment, loss of a professional license, and ineligibility for government contracts. So clearly, I mean, other than losing your life to execution, I think, and losing your liberty for a very long time, losing your children is one of the greatest penalties that anyone can ever face. So certainly under McCune, that is enough to amount to compulsion under the Fifth Amendment. One other point relating to speech that I wanted to make briefly is, again, relating to conduct. The government has argued that it wants father to change his conduct, not his speech. And they cite several counseling cases, but they really don't support the government's argument. Those are Pickup v. Brown and Wyatt Burry v. Kansas City. In those cases, counselors themselves sought declaratory judgments that the laws prohibiting in their states sexual orientation conversion therapy violated the counselor's right to free speech. And both courts held that although counseling requires language, counseling is primarily conduct, employing various methods to change behavior, which can be, you know, talk therapy, but also can include other things like, in these cases, aversion therapy, where the counselors administered unpleasant electric shocks when the child was viewing images of same-sex couples. So counseling is conduct. But Those laws did not prohibit the counselors from recommending conversion therapy, just from delivering it. But the main point here is that father's therapist for the free speech analysis, if father's therapist, Dr. Nahara, is not the speaker, okay, father is the speaker. So the counseling cases cited by the government do not support the argument that the abuse omission mandate primarily affects conduct. And one last point, I think it might be worthwhile for me to point out that I think the case of all of the different jurisdictions on self-incrimination that the parties have cited, the one that appears closest to the facts of this case to me is in the matter of ADL from Nevada, 133 Nevada 561. There, after a toddler suffered a burn, the mother admitted that the child had been injured in her care, but maintained that it had been an accident. And mother completed all of the tasks. She got stable housing, she got stable income, and all of the services that the plan had assigned to her. But she still refused to admit that she had abused the child intentionally, that the burn had been anything other than an accident. And the Nevada Supreme Court held there that the department had violated mother's right against self-incrimination by recommending termination of her parental rights because it compelled her to choose, right, between her right against self-incrimination and her fundamental liberty interest in the parent-child relationship. And again, she, like father, had met all of the requirements except this one.
In Nevada, though, they allow the consideration of the therapy information as to whether there has been an admission or not, but then looked at all the other factors in that case, right? So it was a very case-specific analysis. But Nevada allows consideration of whether somebody made that acknowledgement or admission, right?
They do, but the question is whether it is, the deciding factor.
Right.
Okay. Thank you, Your Honors.
Thank you, counsel, for your arguments. The court will take this matter under advisement.
E ku iluna, please rise. Ua ho'oku'u ia mai ne kea aha ho'okolo ki iki hanahano o ka moku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.